Today in this video we are going to see about the Employees Compensation Act. Previously it was termed as Workmen's Compensation Act. After amendment it has been termed as Employees Compensation Act 1923 and amended thereof. Now we will see, previously we have seen the introductory part. Now we will see how the compensation is claimed and what are the repercussions on the claim, that we will see in this video. So we are going to see from section 3 to section 18. So we are going to cover some 16 sections. We will see one by one. So first we will see the section 3, liability, employees liability for compensation. So during the course of employment or out of employment or in the course of employment, if the accident occurs or happens due to which the injury may cause, and that may cause, the injury may cause death or partial disablement or permanent disablement, for which the compensation has to be paid by the employer. So we will see how, what is the liability, employer's liability for compensation, employer's liability to employee. What is the reasons behind it, how the liability arises? Because of the personal injury. If the personal injury happens to the employee, the liability arises. The liability of the employee to give compensation arises. Second reason, caused by an accident, that is unknown to anybody. Accident means suddenly occurring the things. Even it may be due to contributory negligence, that will not form a part of the for relinquishing the claim. And third one, the accident arisen out of employment or in the course of employment. So it is purely due to out of employment, due to employment or in the course of employment, means while doing the work, the time and premises and other things are counted. Then injury resulted, the injury might have resulted in death or partial disablement or total disablement. These things are the reasons for claiming the compensation, and thereby the liability arises. So the employer has to give compensation to the employee. Second thing, when the employer is not liable for compensation, when the personal injury does not happen or it is not caused by an accident, and the accident has not arisen out of employment or in the course of employment, these are all the reasons for not liable. The employer is not liable to pay the compensation to the employee. And the third thing is employer liability in case of occupational disease. So whenever they are doing, the employee is doing the occupation, somehow the employee may contract some occupational disease. For that the employer has to pay the compensation. So under what circumstances the occupational disease? Probably it may be due to inhaling of poisonous gases, or the skin may contact with the chemicals or some of the things which are produced by the organization. So there are it is mentioned in Schedule 3. The occupational disease are mentioned in Schedule 3 of the Employees Compensation Act. So there are three it has been divided into three categories. So category A, B, C. Category A, no specific period of employment. Suppose if the period of employment is specific, whether it is specific or not, even if they work for a month, they are eligible. That is called section A category employees. Then the second thing is, if the employment is purely contract, then they are coming under B category. Then C category, the employees specified or notified by the central government they are coming under C category. So when the liability arises due to personal injury and also due to accident, that is arising out of and in the course of employment. So we can see the case study also in the state of Rajasthan versus Ram Prasad and others. What happened in that in the worker may be exposed to, suppose if they are a boy employed for bringing tea to the workers, and while coming some mishap may happen, arson may happen, due to which the boy died, for which it is considered as the accident or the death happened in the course of employment. Then we'll see, and in some cases while fetching food to the employees, if even though it is not occurred inside the campus or inside the premises, it is also considered as the accident during the course of employment. And notional extension of employer's premises, that is, the premises usually when the accident happens within the complex, then it is considered for the compensation. But sometimes hence the starting time by the employee from house to the working place is not at all considered. If anything happens in between that, it is not considered for compensation. Like that, if they return to the house, if they leave the complex, if they leave the premises of the working place, then it is not considered. But in some cases, it is the notional extension, that is the extension of employer's premises. The premises is considered as extension, it can be extended. For example, the worker cannot reach the work spot on his own accord. So some train is fixed. By the train only you have to come to the work. From there, after completion of the work, he has to go by the specific train. Like that, some arrangement is there between the employer and employee. And if the accident occurred in the en route of his journey, then it is considered as the thing happened, the accident happened, injury happened in the course of employment. Like that, some vehicle may be sent by the employer for carrying the employees to the premises. Then if anything happens, injury happens during the transportation of the employee, then it is also considered as the accident occurred in the course of employment. Then these are all the notional extension of employees' premises. Liability, sometimes the liability of insurance company is also there. Then section 4, amount of compensation, how the amount of compensation is calculated. So for calculation purpose, the causal connection between the accident and the injury should be there. Causal means cause, what is the cause behind it? So the causal connection between that is the occupation and disease, or the accident and accident to the employee. So in case of the liability of insurance also is there, and when two claims are there, then the work, whether it may be claimed by workman compensation under Compensation Act or under Motor Insurance Act, that is insurance, that is general insurance. So the liability in the case of death, 50% of the monthly wages plus the relevant factor is also considered in the case of death due to the injury during accident while doing duty. Then 60%, suppose if the total disablement if happens due to injury, then 60% of monthly salary is calculated. Then suppose partial disablement, 20% of the monthly wages can be calculated. So these are all for calculation purpose, amount of compensation. Then section 4a, compensation to be paid when due and penalty for default. That is, whenever the compensation is calculated and accepted by the employer, then it is due to the employee, then it has to be paid. And if at all if it is not paid, the penalty will be levied to the employer, and the penalty will also be added, and that has to be paid to the employee. These are all decided by the Commissioner of Workmen's Compensation Act, that is Employees Compensation Act. Then method of calculating wages. The method of calculating wages is always the monthly wages is taken as calculation, and the percentage is fixed. 50% in the case of death and 60% in the case of total disablement. Like that, the calculation of wages, and the calculation of wages is always monthly wages. If the employee is more than 12 months working, more than 12 months, the average monthly pay is calculated. Suppose if he is a contracting employee, then he is working only for a month, then the notional yearly pay will be calculated and the monthly pay will also be calculated. These are all method of calculating wages. Review. Section 6 says about the review. Review means always when there is a verdict or compensation is allotted or accepted by the employer, then the review is always lies with the employee. Suppose at the time of injury, partial disablement will be there, and in the course of time it may become permanent disablement, for which there will be a variation between these two, and that has to be accepted by the employer. That is called review. And while doing review, the already calculated amount should be paid initially to the employee, and afterwards the revised fixed compensation can be paid to the employee. That is called the review. Then commutation of payments. That is, the commutation of payments means instead of giving the monthly wages fixed, that is, it may be off monthly wages or 60% as fixed by the commissioner. After 6 months of the payment, it can be calculated for the remaining period, or accordingly the compensation is calculated accordingly, and then that is paid in lump sum. That is called commutation of payments. Half monthly payment for 6 months. First, for 6 months, half monthly payment is made, and then subsequently the commutation is made. That is, for each month afterwards, for the total period of his service is calculated, that is the factor, and then the amount is calculated in total and the lump sum is paid. That is called commutation of payment. And distribution of compensation. Usually the compensation is made through commission only. Whenever the acceptance of the compensation by the employer, then it has to be paid to the employee, and the amount fixed by the commissioner has to be deposited to the commissioner, and through commissioner it has to reach the employee, and that is called distribution of compensation through commissioner. That is section 8. Section 9 says compensation not to be assigned, attached or charged. So the compensation is specifically allotted to the injured employee by accident during the course of employment. It cannot be, under any circumstances, it cannot be assigned or charged or attached. So it has to be, the intention is it has to reach the employee directly or to the heirs, legal heirs. Then notice and claims of accident. So the any accident happens in the premises, the employer should inform the accident by way of notice to the commissioner within 30 days from the occurrence of the accident or injury. Either it may be the death or it may be partial disablement or total disablement. Then 10A, power of employer's statement regarding fatal accidents. So it is always the responsibility lies with the employer. In case of fatal accident or any injury happens, it has to be intimated to the commissioner. The statement to be sent to the commissioner on the occurrence of accident. That is the duty of the employer to intimate the occurrence of the incident to the commissioner. Then medical examination. So on the medical examination is always conducted by the employer. The medical examination is free of charge. So the employee who suffered injury due to accident has to submit himself to the medical doctor for medical examination. He has to present himself to the doctor who is available in the premises. No charge is levied for that, and a certificate is given by the medical examiner or the doctor. That is, then the contracting. Section 12 says about the contracting. So when some of the job is given to the contractor, when they are doing the employee doing the work, and during the conduction of work, if accident happens, the contractor alone is responsible and not the principal. So here the principal, agent, that the contract is in between principal and agent. So the contractor is held responsible for the accident and he has to pay the compensation, not the principal employer. In the case of Kudankulam versus superintendent engineer and others, the PWD department constructed a wall, and while constructing 3 employees died, and then it has been decided the PWD is indemnified by the contractor. So the contractor has to pay the compensation to the PWD. Then contracting. And section 13, remedies of employer against stranger. Remedies of employer against stranger. In this case, the principal is the employer and the contractor is the agent, and he may also give contract, the work can be given or allotted to subcontractor. So here these 3 parties involved, that is the employer is the principal and contractor is the agent and subcontractor is the sub-agent. So he is considered as stranger. The contractor, subcontractor is considered as stranger. In the case of stranger, the sub-agent alone is responsible to the contractor and contractor is alone responsible to the principal employer. And then section 14 involves insolvency of the employer. That is, when the insolvency of the employer, then the insurer is liable. Suppose if it is insured, the insurer is liable for compensation. Then special provision, that is section 15, special provision relating to masters and seamen. So what is the relation? When the ship the master and the seaman, if any accident happens to the seaman, the master is liable. And if it happens to the master also, then it has to be paid by the compensation act covers, and it has to be the intimation has to be sent to the commissioner, and it will be the compensation will be paid from the by the commissioner on from taking the compensation from the owner of the ship. So in such a way, the special provision relating to master and seaman. Suppose if the ship itself is the where it has gone, so it might have gone out of peril, or it might have sunk in the sea, then the claim can be made by the dependent legal heirs, and they are eligible for the compensation. Then section 16, return as to compensation. That is, what is meant by returns means the statement. Returns means it is nothing but a statement. So whenever the compensation has to be paid, it has to be the compensation has to be informed to the state government, and the state government will publish in the official gazette who are what all the accident happened, date of occurrence of the accident, and how much he paid during last year and this year, like that it will be published in the gazette. That is returns as to compensation. Returns means statement. This statement is to be sent from by the employer, and it will be published by the state government in the official gazette. Then section 17, contracting out. Suppose if the work is given to some other contractor, then the contractor is liable for the compensation. That is contracting out. Then section 17A, duty of employer to inform employee of his rights. So whenever it is always the duty of the employer, or it is always the important thing which has to be kept in mind by the employer, that he has to inform the employee of his rights. What are the rights which the employee has he is having on the accident arising out of employment. So duty of the employer to inform employee of his rights. So what are the rights of the employee, how much compensation he can be taken, and what is the thing behind it, what are the how much compensation he can have. All this information has to be given by the employer. That is under section 17A. This 17 contracting out means, that is, if it is suppose if it is the employee actually they are responsible, the employee suppose if has suffered injury and some accident happened during the course, he can be reappointed by the and regular pay will be given by the employer, but subsequently he may be sent out. So in such of those cases, actual compensation has to be calculated and paid. That is called contracting out. That is according to section 17. Then section 18, penalties of a failure to send statement to commissioner. When the statement should be sent, what are the statement to be sent? One is what is the when the accident happened, what is the injury, type of injury, whether it is permanent or partial. All these things are to be informed to the commissioner. If that is not sent properly to the commissioner, then the employer is liable for the compensation apart from the penalty. The penalty will be levied as per the bank interest, and that will be given to the employee. So all these things we have covered in the Employees Compensation Act. தமிழிலே ஒரு எம்ப்ளாயீஸ் வேலை செய்யும் பொழுது அவர் ஒரு ஆக்சிடெண்ட் விபத்தின் காரணமாக காயப்பட்டாலோ அந்த காயமானது அவரை நிரந்தரமாக வேலை செய்ய விடாமலோ அல்லது அந்த குறிப்பிட்ட வேலை இல்லாமல் வேறு வேலை செய்தாலோ அதற்கு பார்ஷியல் டிசபிள்மெண்ட், டோட்டல் டிசபிள்மெண்ட் பெயர். இதில் ஒரு முக்கியமான லயபிலிட்டி பொறுப்பு என்னவென்றால், அந்த எப்பொழுது காம்பன்சேஷனுக்கு எலிஜிபிள் எம்ப்ளாயர் ஒரு வேலை செய்பவர் அவர் பெறலாம் என்றால், ஒரு பர்சனல் இன்ஜரி ஒரு காயப்பட்டிருக்க வேண்டும். அந்த காயமானது ஒரு அவரை வேலை செய்ய விடாமல் தடுத்திருக்க வேண்டும், அல்லது அது டியூட்டியின் மூலமாக செய்யும் பொழுது நடந்திருக்க வேண்டும். இது இவ்வாறு நடந்திருந்தால் அந்த இழப்பீடை கோரலாம். இவ்வாறு நடக்கவில்லை, இந்த காரணங்களுக்கு இல்லாமல் என்றால் இழப்பீடு கோர முடியாது. அடுத்ததாக ஆக்சிடெண்ட் என்பது திடீரென நடப்பது யாருக்கும் இது. அவ்வாறு நடக்கும் பொழுது அந்த இந்த கோர்ஸ் ஆஃப் எம்ப்ளாய்மெண்ட் அவுட் ஆஃப் எம்ப்ளாய்மெண்ட்டாக இருக்க வேண்டும். இது சமயத்தில் இதில் முக்கியமானது என்னவென்றால், அந்த ப்ரிமிசஸுக்கு வெளியே நடப்பது கூட அவர்கள் அதற்கு அந்த எம்ப்ளாயர், அதாவது வேலை கொடுத்த முதலாளி அந்த வேலையாட்களுக்கு இழப்பீடு தர வேண்டும். ஏனென்றால் ஒரு டீ பாய்க்காக ஒருவரை அமைத்திருந்தால் அது வரும் வழியில் அவர் அப்பொழுது ஒரு கலவரம் நடந்து அவர் இறந்திருந்தால் அது அந்த அவருக்கு நஷ்டஈடு வழங்கப்பட வேண்டும். அல்லது ஒரு உணவு கொண்டு வரும்பொழுது நடந்திருந்தால் நஷ்டஈடு கொடுக்கப்பட வேண்டும். அடுத்ததாக நோஷனல் எக்ஸ்டென்ஷன் ஆஃப் எம்ப்ளாயர் என்றால், ப்ரிமிசஸுக்கு வெளியே சில இன்சிடென்ட் நடக்கிறது. இப்போ வேலை சொன்ன உதாரணத்தின் மூலமாக அவ்வாறு நடக்கும் பொழுது அப்பொழுதும் அவருக்கு அந்த ப்ரிமிசஸினுடைய எக்ஸ்டென்ஷன் விரிவாக்கப்பட்டு பட வேண்டும். அது அப்பொழுதும் நஷ்டஈடு தரப்பட வேண்டும். அடுத்ததாக எவ்வளவு பணம் தரப்பட வேண்டும், அமௌண்ட் ஆஃப் காம்பன்சேஷன். அப்பொழுது அது அந்த ஆக்குபேஷனல் டிசீஸ் வந்தால் கூட அவர்களுக்கு நஷ்டஈடு வழங்கப்பட வேண்டும். அது தொடர்பு அந்த தொழில் செய்கின்றதோடு தொடர்புடையதாக இருக்க வேண்டும். அடுத்ததாக என்னவென்றால், எவ்வாறு கால்குலேஷன் செய்யப்படுகிறது மதிப்பீடு, ஒரு மாத சம்பளத்தை கணக்கிட்டு அதில் 50% அல்லது 60% நிர்ணயிக்கப்படுகிறது. அடுத்ததாக ரிவ்யூ என்பது என்னவென்றால், ஒருவர் விபத்து நடந்த பொழுது அவருக்கு பார்ஷியல் டிசபிள்மெண்ட்டாக இருக்கலாம், பிறகு அது டோட்டல் டிசபிள்மெண்ட்டாக மாறும் பொழுது அந்த இழப்பீடானது அதிகப்படுத்தி கொடுக்க வேண்டும் என்பது ரிவ்யூ என்று பெயர். அதற்கு ரிவ்யூ பெட்டிஷன் செய்து, கமிஷன் ரிவ்யூ பெட்டிஷன் செய்து அதனை பெறலாம். அடுத்ததாக கம்யூட்டேஷன் ஆஃப் பேமெண்ட்ஸ். ஒரு உடனடியாக ஒரு 6 மாதத்திற்கு 50% சம்பளம், மாத சம்பளத்திலிருந்து 50% கொடுக்கப்படலாம். அதற்கு பிறகு அதனை அவருக்கு அதோட ஃபேக்டரால் மல்டிப்ளை செய்து அவருக்கு முழு தொகையும் லம்சமாக ஒரு முழு தொகையாக கொடுக்கப்படலாம். அடுத்ததாக கமிஷன் மூலமாக தான் இந்த இழப்பீடெல்லாம் கொடுக்கப்படுகிறது. நோட்டீஸ் கொடுக்கப்படும். கிளைம் ஆஃப் ஆக்சிடெண்ட்டுக்கு நோட்டீஸ் கொடுக்கப்பட வேண்டும். அது ஒரு 30 நாட்களாக நோட்டீஸ் கொடுக்க வேண்டும். அடுத்ததாக ஃபேட்டல் ஆக்சிடெண்ட்டை அதை ஒரு ஸ்டேட்மெண்ட் மூலமாக கமிஷனருக்கு தெரிவிக்கப்படுத்த வேண்டும். மெடிக்கல் எக்ஸாமினேஷனுக்கு எம்ப்ளாயியை, அதாவது வேலை செய்பவரை ஒரு காயம் ஏற்பட்டாலோ அல்லது அவர்களை மெடிக்கல் ஆஃபீஸருக்கு ரெஃபர் செய்ய வேண்டும். அதற்காக எந்த தொகையும் வசூலிக்கூடாது. அது முழுமையாக வேலை கொடுத்தவர்களுக்கு கொடுப்பவரே அதனை இந்த பணத்தை ஏற்க வேண்டும். அடுத்ததாக கான்ட்ராக்டிங் இருக்கும் பொழுது அந்த ஒரு வேலையை ஒரு பிரின்சிபல் கான்ட்ராக்ட் விடுகிறார். அந்த கான்ட்ராக்ட் ஆட்களை வைத்து வேலை செய்யும் பொழுது அப்பொழுது ஆக்சிடென்ட் நடக்கும்பொழுது அதற்கு கான்ட்ராக்டர் பொறுப்பாகிறார். அடுத்ததாக ரிட்டர்ன்ஸ். சில ஒவ்வொரு வாரமோ அல்லது மாதத்திற்கோ ஒவ்வொரு மாதத்தும் என்ன நடந்தது ஏது நடந்தது என்பதை அவர்கள் ஸ்டேட்மெண்ட் அனுப்ப வேண்டும். ஒரு மாதாந்திர அட்டவணை பட்டியல் போட்டு என்ன நடந்தது ஏது நடந்தது, எந்த ஆக்சிடெண்ட், பெயர், எல்லா விவரங்களும் கமிஷனருக்கு தெரியப்படுத்த வேண்டும். எம்ப்ளாயர் கமிஷனருக்கு தெரியப்படுத்த வேண்டும். அடுத்ததாக ஒவ்வொருடைய எம்ப்ளாயரும் ஒரு எம்ப்ளாயிக்கு விபத்து நடந்தால் அவருக்கு என்னென்ன உரிமைகள் இருக்கிறது என்று அவர்களுக்கு தெரியப்படுத்த வேண்டும். அடுத்ததாக இந்த ஒரு இந்த பணத்தை தருவதில் தாமதம் ஆனாலோ அதற்கு அந்த அதாவது அதற்கு வட்டி போட்டு இந்த எம்ப்ளாயர் கொடுக்க வேண்டும். இத்துடன் we conclude this video with this.